What I'm going to speak about today is sort of three things really, a couple in more detail than the other one, but the first is the duty of care of those involved in telemedicine, and it's a bit of a subset of that, which is what is the standard that each person involved owes, and the second aspect is do all involved in facilitating a service by telemedicine owe a duty to the patient. And the second aspect I want to talk about is insurance. So are all of those involved in delivering telemedicine, are they indemnified for their errors? And finally, I'll talk about credentialing, and that's sort of two subsets to that, and in particular whether a health service can be liable for negligent credentialing, and do healthcare telemedicine providers need to be credentialed, and if so, by who? Now that all sounds a bit oblique, but by the time I've finished, hopefully it'll all be very, very clear to you. There are two components to the duty of care, and they are these: the health service or the health practitioner to whom the stroke victim has presented for treatment, and the health service or the health practitioner who provides the services. And I've conveniently divided them up into two, which is the called one the host provider and the other the telemedicine provider. Now, the host provider. So the host provider is the person who presents at a facility and is expecting or is to receive care, and part of that care is going to be delivered via some technological means. Now, the host provider, and let's assume it's a facility and not an individual, but the host provider has a duty to exercise reasonable care in the provision of healthcare services to its patients. And that sounds very obvious. It won't be any surprise to you. But the other aspect might be, which is the duty is non-delegable. So what does that mean? We'll take a step back. I'll just deal with the individual and then the facility, but a medical practitioner has a duty to exercise reasonable skill and care in accordance with the skill that the medical practitioner professes to have. So what I've put there is, put simply, if you profess to have the skill of an orthopaedic surgeon, then that's the standard you must live up to. If you're a general practitioner and someone comes to see you with a broken arm and you profess that you have orthopaedic surgical skills, then that's the standard of care you have to live up to. It's a bit like, you might think, well, why is that? Is that unfair? Well, I should perhaps ask a question for those in the audience. If you're on your L plates and you're driving around the road, what standard of care do you owe to your fellow road users? I mean, you're a beginner and you've got an L plate on to show that you're a beginner. Anyone prepared to hazard a guess? No one has a guess. I should pick a volunteer, but I won't. Maybe you're afraid of being wrong, but the standard of care is not of a learner driver. The standard of care is that of a reasonable driver. So you might find that surprising, but that's the way it is. And it's the same in medicine. If you profess to have a particular skill, that's the standard of care you're held to. Now, a health service has a duty to exercise reasonable care in the services it provides, and we discussed that before, and that's no surprise to you. Now, the next bit is a bit more difficult, which is, does a rural health facility with little experience treating stroke victims have the same duty as a tertiary institution with vast experience treating stroke victims? Now, you might think, because of that example I gave you about the road user, that you would, but that's not the case. There is a lack of case law about this, and arguably it would be the full duty, like I said before. And in fact, if this was up before the courts and if I had an opponent, that opponent would be arguing that case law says that the learner driver owes the same standard of care of a reasonable driver on the road. So a health service providing treatment to a stroke victim owes a standard of care that would be expected of a health facility providing care to a stroke victim. However, I don't believe that that is the case with health service providers. I believe that the case with the health service provider is that the health service provider is obliged to provide or to live up to the standard of care for the services which it professes to offer. The example I've given is that if a rural health service has an emergency department, then it must live up to the standard of care of a reasonable emergency department. So if a reasonable emergency department, let's say, has facilities to treat stroke victims, and the fact that it's a stroke victim is irrelevant, but if an emergency department, if what is expected of a reasonable emergency department is to be able to treat stroke victims, then that's the standard of care you've got to live up to. And a number of hospitals have effectively got themselves into trouble, when I say trouble, that they've found themselves in precarious liable situations because they have put on the sign out the front of the hospital, the emergency department, when in fact it's not that. And those of you who work in or have taken notice of rural health facilities, you might find that many of them now don't have those signs, that what they have is signs with differential type descriptions such as urgent care centre, because they want to move away from the perception that they're an emergency department, because what the public expects of an emergency department is the sort of care that they can't offer. So if you put a sign up the emergency department, you better be able to deliver it. But if you put up a sign, an urgent care centre, and it's well known, that it's either well known or portrayed to a patient what services they're entitled to expect, that's fine. There are many cases, in fact we have a case running at court today in which a person attended a rural, I'll call it urgent care centre, and the care is provided by general practitioners, and the general practitioner was called, and what's in question is the standard of care of that general practitioner when it came to, well, it's alleged that what should have happened is the young person who attended, very young person, young child, attended, should have been intubated. And there's a dispute about that. The case is effectively about that. But fortunately for us, we didn't hold ourselves out as having an emergency department. We had, the hospital had the appropriate sort of labels, if you want to call it that, and it was pretty clear what facility it was offering. Now, the important bit is that the health facility, I said before, has a duty to take reasonable care in the delivery of health services to its patients. That duty is non-delegable, and what that means is that if any part of that duty is delegated to somebody else and that person makes a mistake, then the facility is liable for it. The example I've given, that is if a public patient at a hospital attends the hospital and they're expecting, as they are entitled to as a public patient, to have all of their care attended to and paid for by the hospital at no expense to it. If the hospital chooses, as it is entitled to do, if it chooses to outsource a radiology facility to an outsourced radiology department, if that radiologist makes an error in reporting on the radiology report, then the health facility is liable for that radiologist's error. Now, it doesn't mean the radiologist is not liable, the radiologist is liable as well. But if the patient chooses to sue the health facility, it's no defence for a health facility to say, well, hang on, I delegated that, we engaged a radiologist and they made the mess of it, we should be liable. Now, we shouldn't be liable. Now, you might think that, oh, that's fair enough, or that may make logical sense to you, but it's not the case. If you engage, say, a builder to come around to your house and repairs your house and engages an electrician to do part of the work, the builder's not liable for the faulted electrician because the builder doesn't have a non-delegable duty. The builder is only obliged to you to take reasonable care in the services that the builder delivered, and engaging a qualified and competent electrician is a perfectly reasonable thing to do. It's not the builder's responsibility that the electrician made a mistake. Now, you may have a contractual relationship with the builder that makes them liable, but I'm just talking about the normal relationship where somebody turns up and does work for you, that it's perfectly reasonable that they delegate it. There are not many situations of non-delegable duty in Australia, and health service providers are in the privileged category of being one of them. Schools are another, and there, as I said, there aren't many. Now, what's the duty owed by the telemedicine provider? I've got here that the two potential duties are to the host provider and to the patient. So the person at the other end who's been contacted to effectively assist the host provider or to provide an opinion or to do some part of the treatment, what duty do they owe? Well, you could break that down into two. And the two are, well, what duty do they owe to the organisation, to the host provider, so the organisation that's contacting them to get involved in the patient care or to provide a second opinion or an opinion. And then secondly, there's to the patient. The relevant authority for all of this is an old 1980 New South Wales case, which the facts were these, is that the plaintiff was admitted to hospital and treated by an orthopaedic surgeon, and a second opinion was obtained from a neurosurgeon. Traction was performed, and as a consequence, the plaintiff suffered a deformity of the spine, rendering him a paraplegic. The plaintiff sued the hospital and both doctors, and it's clear from what I've said to you before that the hospital owes a duty of care to that patient for two reasons. One, it owes a direct duty to the patient, and secondly, it has a non-delegable duty of care for anybody who might have treated them whilst under their care, but I won't divide that up anymore. It's also clear that the orthopaedic surgeon owed a duty, and in this particular case, the orthopaedic surgeon was treating the patient directly. This is not a second opinion. This is the primary surgeon responsible. But as far as the neurosurgeon, what about the neurosurgeon? The neurosurgeon didn't actually consult with the plaintiff, and all the neurosurgeon did was, after a note was to the neurosurgeon to provide a second opinion, made a note in the medical record receiving the consultation from the orthopaedic surgeon, and presumably there was some reliance upon the neurosurgeon for proceeding with the traction. And what the judge, and it was just a single judge, what that judge held was that the neurosurgeon knew and accepted that the question of the possible danger to the plaintiff's spinal cord would to some extent have been dependent upon his advice, and that factor alone was enough to establish a duty owed by the neurosurgeon. Now, there's no Victorian case law on that point, which would surprise you. I mean, I'm sure when I said that, is there a duty owed by the telemedicine provider to the patient, that you would have all said, of course there is. Well, the reason why it's not clear is that in a normal doctor-patient relationship, the patient chooses their doctor and there is an arrangement between the two. But in this particular case, if you can understand the dynamics a bit, is that when the patient attends the host provider, the patient may well not have any input into the second opinion and from whom it's being obtained. The patient may not be asked if he's or she's got a preference, and it just might be that the host provider, in delivering the service, is calling upon the telemedicine provider for assistance. So it might be that the relationship is actually between the telemedicine provider and the host provider, rather than between the patient and the telemedicine provider. But if you rely upon Albrighton, which I think is good law, that it's fair to say that if the telemedicine provider were to know that some reliance was going to be placed upon his or her advice in treating the patient, then that would give rise to the duty. I mean, it might be different. I don't want to answer this question, I'll just sort of pose it, is that it might be different if a radiologist at one site sought an opinion from a radiologist at another site as to what they saw on a film. It might be that the second radiologist could not have reasonably expected that reliance was going to be placed upon his or her opinion because they're both radiologists. It might have been just a second opinion. So it's not a certainty that the duty will arise always when there is a telemedicine provider. So in summary on that is, does the telemedicine provider owe a duty to the patient? Well, in my opinion, yes. So what happens if the telemedicine provider acts negligently? Then what I say is that in that circumstance, the patient could choose to sue both the host provider and the telemedicine provider, or either of them. And the reason I say that is that if the telemedicine provider is negligent, it's likely, in this circumstance I've been talking about, where a patient presents to one facility for treatment and that facility seeks the input from somebody else, that in that circumstance, the plaintiff only need choose the host facility at which he or she presented at, because that facility owes, as we said, a non-delegable duty of care. It owes a duty to the patient, and that duty is non-delegable. So when it farms out some of the processes or tasks to somebody else, the host provider remains responsible. The patient may also sue the telemedicine provider. Why do they need to do that? Well, why could they do that? Well, given that they've already established under the principles of Albrighton that the telemedicine provider has a duty to them, if that telemedicine provider breaches that duty by making a mistake, then the patient could sue the telemedicine provider as well. So the patient has a choice. The patient, in fact, the likelihood is that the patient will sue both and let the health facility and the telemedicine provider fight it out between themselves, but most likely that he'll sue both. Now, when I said before that the health facility is liable under the principles of non-delegable duty of care, if the error is made solely by the telemedicine provider, so let's say that there's an opinion is sought from a radiologist, let's say, and the radiologist gets it entirely wrong and the host provider has nothing to do with the radiology reporting or input onto what the films read, then whilst the host provider would be liable, the host provider would be able to, what lawyers refer to as seek contribution or indemnity from the telemedicine provider. And the likely outcome of that would be that the telemedicine provider would have to pay everything, so that the plaintiff would win against the host provider and would win against the telemedicine provider, but the telemedicine provider, the host provider in its separate on-the-side action would recover everything from the telemedicine provider, because the telemedicine provider was the only person in that chain of events that did something wrong. So ultimately they should bear the responsibility if the health facility wants to get part of its liability back, which no doubt it would. Now I just want to touch briefly, if I may, on insurance. And I mean, I can't touch on all aspects of insurance because there are so many of them, but in Victoria, of course, the main body of insurance is for the Victorian Public Health Services, and there is a policy issued covering all those services by the Victorian Managed Insurance Authority. And the policy covers two types of indemnity. One is for public patients of those health facilities and the other one is for private patients of those health facilities. For public patients, that entitles or that covers the health services whilst treating the patients as public patients, and the health service in those circumstances is entitled to indemnity. That's straightforward. For private patients, health services who hold the policy are, whilst treating their own private patients, so there might be a privately engaged doctor, but whilst treating the private patients, the health facility is entitled to indemnity in respect of the claims made against them. But what they're not liable for, and therefore they don't even need insurance, is they're not liable for the acts of the private treating practitioner. So if you're a private patient in a public health facility, in fact, if you're a private patient in any health facility, then you've got an agreement with your treating practitioner to deliver the medical services. The health service has not undertaken to deliver the medical services. So if you go to a private hospital for surgery on your knee and you've got a private orthopaedic surgeon, you've engaged that orthopaedic surgeon to provide the care, management, surgery on your knee. What the hospital's provided, or what the hospital has undertaken to provide, is hospital services. The hospital only undertakes to provide hospital services. Those hospital services are theatres, nursing staff and the like, not medical treatment. So all decisions about the medical care, and the surgery itself are the responsibility of the private surgeon. So the hospital is not liable for that. And it's the same if you're a private patient in a public hospital. The public hospital is not liable for the services upon which the private surgeon or private doctor was engaged to deliver. Now, in those circumstances, the hospital is covered for the services it provides, but it could expose itself to liability if the private treating, and I'll call it, stick with the surgeon, the private treating surgeon is negligently credentialed. So if you've got a Dr. Death at a hospital and the hospital ought to have known that Dr. Death was behaving like Dr. Death and allowed that person to either be credentialed or to remain credentialed, then not only would the doctor be liable, but so would the hospital. That's a very rare and unlikely event, but can happen. The indemnity policy includes as insureds, and there are two relevant definitions that are applicable to those providing services in the public sector, and it's these. And whilst the policy is taken out by the hospital or the health service, it extends to other people. So those other people are actual beneficiaries of the policy. And I've used the words advisedly when I say in Victoria the VMIA policy includes as insureds. It's as good as if you took out the policy yourself effectively. So these two categories of people are covered as if they had taken out the policy themselves, and it's these employees of the health service who are registered medical practitioners while providing advice to another health service or medical practitioner in respect of the care or treatment of a patient of that health service or the other practitioner. So if you're an employee and you're providing advice to another, if you're an employee of a public health service and you're providing advice to another health service or another medical practitioner, then you are covered under your health services policy of insurance. The second one is an interesting one, which is persons for whose conduct the health service or organisation is liable at law whilst providing healthcare services to public patients of that health service or organisation. Probably means nothing to you. Actually, it's sort of lawyerly gobbledygook, I'd imagine. But it's important because who it's relevant to is the person who provides the telemedicine advice, not the host provider, the person who provides the telemedicine advice. Because what it says is persons for whose, so this policy insures persons for whose conduct the health service, so the host provider, is liable. And if you've been listening and absorbing it, then as we discussed before, the host provider has a non-delegable duty of care to its patients. When it engages the telemedicine or involves the telemedicine provider, the host provider is liable for the telemedicine provider's conduct. So is the is the telemedicine provider a person for whose conduct the health service is liable? Yes, because of that non-delegable duty of care. So that non-delegable duty of care is vital in establishing that. So it means that there's two things, that if a telemedicine provider is an employee of a public health service and is providing advice to another health service or to another medical practitioner in their capacity or in his or her capacity as an employee, then the telemedicine provider is covered, notwithstanding if they are not a member of the health service to whom they are providing that advice or to the patient that they're providing that advice. The second part is that the telemedicine provider is indemnified under the policy whilst providing advice to public patients of the host provider. They're covered for that as well. So if it's a public patient, it's covered. The next thing I wanted to mention was credentialing. Now, can a health service be liable for negligent credentialing? Well, the answer is yes. It's just like any other issue of hospital management, that if somebody is injured by negligence of the hospital or health facility, then there can be a liability to the patient. The lawyers talk about a thing called foreseeability, which I don't need to bore you with, but basically the concept is you're liable if the injury suffered was reasonably foreseeable, that if a person objectively looking at the scene of what was going on would consider that the injury that it sustained was something that was foreseeable. So you can imagine it, that if a doctor is wrongly credentialed or negligently credentialed, then any injury to a patient by virtue of that doctor's inappropriate credentialing could give rise to an injury for which would be foreseeable. And it sort of happened a lot. I mean, there's lots of actions in which hospitals cancel accreditation or take practitioners to court to try and restrict their accreditation. And it's important that they do that, because absent that if they don't, if there is an incident and a patient says, well, it might have been, the doctor made a mistake, but that doctor was not capable of performing this, or providing the treatment that they provided to me and I was injured as a consequence, then liability will be established. So the two other questions I wanted to deal with is, so do healthcare telemedicine providers need to be credentialed? So if you're providing telemedicine advice, or well, either to the patient or to the, no, I'll withdraw that. If you're engaged or contacted by a host service to provide advice, do you need to be credentialed? And it's the two issues there are, do you need to be credentialed by the host provider, or do you need to be credentialed by your own organisation? And that's assuming that you're part of an organisation when you're providing that telemedicine advice. The answer is it depends whether the host provider is asking another organisation to provide the telemedicine services, in which case the health service providing the telemedicine services ought to ensure that their practitioners providing the services are credentialed to do so. So if you're the host provider, you're in charge of the host provider organisation, then if you're dealing with another provider or another organisation, you ought to ensure, if you can, that those providing these services are credentialed to your organisation. That might pose a challenge, but it's no different really than when you've got a doctor providing services or anybody providing services at your facility, physically at your facility. If they have to be credentialed, why doesn't somebody who's providing it via telemedicine need to be credentialed? Why can you rely upon just picking somebody out of the yellow pages because they say that they're a psychiatrist, that's appropriate that they provide telemedicine advice just because that was the length and breadth of the investigation that you did? That wouldn't be acceptable if you were providing patients at your facility with services, so why would it be sufficient if the services were being provided by telemedicine? The other aspect is if the host provider seeks the services directly from a health practitioner, so in which case you're not going to another service, you're just going to another practitioner, then for the reasons I've just said is that that practitioner ought to be credentialed. Now, the final slide that I had was really something that I don't really need to read out. It was just really there for your benefit as to, well, what is credentialing? I mean, I've stood here and talked about it, and I suspect that most of you know what it is, and what is the scope of clinical practice, because when people talk about credentialing, they talk about putting limits around the scope of somebody's credentialing. Now, what I've quoted here is from the former Australian Council for Safety and Quality in Healthcare, which developed that standard, which has been adopted by the Victorian Department of Health. So for those of you who have any quandary as to what actually is credentialing and what the parameters of it are and what you would be required to do in ensuring that somebody is credentialing, they're the definitions that you need to to resort to. And I'm happy to, if there's time, I'm happy to take any questions that anyone may have on any subject on any of that. That's a good question. I apologise that I didn't actually include that because most of my presentation was really about where input is sought via telemedicine. But if the whole consultation is via is a telehealth consultation, then there is a direct relationship between the telehealth provider and the medical practitioner, and it is just a normal relationship as if you attended the medical practitioner in their consultation room. So all of those situations would be the same as if it was a physical presence. And I'm not sure if I've answered what you need to know on that, but elaborate if I haven't.
It goes to the point.
Well, you've sort of caught me on the run with that. I'd probably need input from you, or from practitioners, so I'm not sure if you're a medical practitioner, but as to what the differences might be. I mean, I can think of some, but...
Okay, so one would be that you actually don't touch the patient, and any examination, so your examination is limited, either limited by the fact that the person at the other end has to examine for you, and you have to interpret their examination visually and through dialogue. That would be the main one. The clinical narrative, the history taking, would be the same. Does it affect the way the patient delivers you the history? Are they shy because they're on camera, or so you could start. You can see where I'm going with that. You could start to say, well, is it really a separate process?
Yeah, no, I think I can answer that. Is that the example you gave is a good one, where you can't physically touch the patient, and let's use somebody who's presented with a concern from a breast lump. Well, obviously they need to palpate it. In that circumstance, the telemedicine provider can do all the normal things about taking history but can't examine the patient. So if what they heard on the history wasn't sufficient for them to be certain to make a diagnosis, then unlike in the consultation room where they could take the next step and make their own decision by the palpation, they would be required in that circumstance to refer them somebody else so the physical examination can take place. So maybe you're right that the person who's providing telemedicine services needs to have a different skill set. And I suppose if you're doing it as part of an organisation, part of the credentialing might be to understand those things. Now, that one is very obvious, but there might be some things which, and I can't think of them, where the medical practitioner, because they may be used to dealing with, in consultation rooms, in dealing with e-health or telehealth, may be required to act slightly differently.
Hello, Mark Savage here from Bendigo. Just for clarification on the credentialing issue, are you saying that Bendigo Hospital should credential the neurologists that give telemedicine advice to the doctors in Bendigo and the ED department? Or are you saying that Bendigo Health and other regional providers can devolve responsibility for credentialing, say, to the Florey Institute? Can you clarify that?
Yeah, sure. I suppose what I'm saying is if you have an arrangement with a particular individual that does this all the time, then you ought to have that person credentialed to your hospital. It may not be a great deal of investigation you have to do, but they should be credentialed. If it's the organisation that you're going to, let's say you're going to the Alfred Hospital and that doctor that you occasionally use, let's say it's occasionally, is at the Alfred Hospital, you only need to be reasonably satisfied that that neurosurgeon is accredited at a major tertiary centre. Now, what reasonably satisfied means, I don't know, but I presume just the fact that you know that they are working at the Alfred Hospital and you've got no reason to believe that they have any reason not to be, that would be good enough.
So it's not crystal clear?
Oh, sorry. Well, then it would be reasonable, unless you had a reason not to I'll start again. Let's do it the other way. You would be entitled to rely upon the Alfred Hospital's credentialing process to accept that they are an appropriate person to provide advice to your facility, right? So unless you had some reason to think that that accreditation is either doubtful or ought not be in place. You may not rate the neurosurgeon. You may think the Alfred's made a mistake. Believe me, they have.
So would a memorandum of understanding be helpful rather than full credentialing?
Sure, yeah. In fact, there is one facility at the moment that has a memorandum of understanding when it's dealing with a public health facility to provide, in an emergency, when their private patient has an emergency, there is a memorandum of understanding about how them contacting the public facility and them delivering services to that patient because the private hospital can't deliver them, and that came out of a disaster that happened, and there was a lack of clarity, communication, so they've done exactly that.
Just a comment to that, and then I'll ask a question. So I'm separately credentialed through the Victorian Poison Information Centre, so I hold an honorary appointment at the Austin Hospital for toxicology advice, and similarly through the New Children's Hospital in Parramatta in New South Wales for the National Poison Centre. So by providing telephone advice on a roster, I have to be credentialed at the point in which that contact is made, which is a little bit different from Memorandum of Understanding. It's a separate credentialing process. So that's just something to consider in a sort of similar advice-giving role. My question is really, you didn't talk about the vertical nature of a referral. So as an emergency physician, when I seek a referral from someone who has a specialty and I refer that patient, explain the situation, and they give me advice, I take that advice on the basis that they have content knowledge that perhaps I don't have. And so when liability is discussed, is it an even playing field or not? Can I say, well, you know, I partially abrogated some of my liability because I took the expert's opinion in the conversation rather than say that we're equally liable? Where does that vertical nature of the referral lie?
I haven't discussed it because I could probably spend 45 minutes discussing that in itself. But the short answer is that if you said to your patient, I'm not quite sure what's going on here, but I think I need neurosurgical input, and I'm going to go and speak to a neurosurgeon, and you come back and say what the neurosurgeon said. If there was a problem with the neurosurgical part of the care, then you wouldn't be liable. If you said to your patient, I've been your doctor for 20 years, I've looked after you, don't worry about this, I'll look after this as well, and then you're not quite sure what's going on, so rather than tell the patient you've got no idea because he or she's got faith in you, you go into the next door rooms and ask a neurosurgeon, you come back and say, all right, you've got this is what I think you've got, and you get it wrong, you're liable because you've represented to the patient that you're in charge of the whole care. So that's the sort of short answer to it.